I am going to announce we are going to stay on the bench, but if anybody wants to leave at this point, they can. But we will stay on the bench after the next case.
Except the two lawyers.
Yeah. Yeah, and I didn't mean to imply that the two lawyers couldn't leave after the next case. They can leave. Okay. Graham, you can go whenever you are ready.
Thank you, Your Honor. May it please the Court, I'm Marjorie Gadarian Graham from Palm Beach Gardens, Florida. I represent the claimant, Ramiro Meneses. I'd like to reserve 5 minutes for rebuttal.
Okay.
It's undisputed that the claimant's disability rating exceeded 20%. The employer carrier conceded this and knew this. Nonetheless, it failed to give the requisite notice that is required by the statute and by the administrative code provisions that implement Section 440.153B. The issue before you, we think, is a pretty simple and direct issue. The JCC made a determination that the claimant bore the burden of proving that there was a lack of notice. I anticipate that Mrs. Saeed is going to focus on the fact that this was not brought out by the claimant's attorney until closing argument, but I would suggest to the Court that is absolutely proper, because when, as in this case, one pleads an affirmative defense that a claimant is not entitled to supplemental benefits, that the burden obviously is on the employer carrier to prove that, and that was the affirmative defense.
But you're saying this is an affirmative defense, but is it really a matter of confession and avoidance, or is it just a denial of the elements of the claim?
Well, the affirmative defense that was pled was a denial of the elements of the claim. But respectfully, if you're going to take the position that you haven't satisfied as the claimant the elements that have to be proven to recover on a supplemental benefits claim, I would suggest to the Court that you also, as the employer carrier, have to prove that you gave notice of the two things that are required under the administrative code, and that is that you are not making at least, or you're making less than, I believe it's less than 80% of what your prior wages were, and of the requirement that you conduct a work search. And the entire case, at least in it's our position, comes down to, was the burden on us to give testimony that that the claimant did not receive notice?
At some point, didn't the carrier indicate that they had not sent a letter because they felt it was premature?
I do not recall that, Judge Wolf.
Okay. But I read that somewhere. I'm sorry.
I think I certainly would have focused on that, and I can tell you I do not recall that in the testimony. Do you have a page citation?
I'm sorry. I'll try to find it, but go ahead.
Well, I'll try to find it as well. But the cases that we cite, and most of them deal with permanent impairment benefits. I don't think any of them deal with this specific issue, but basically stand for the position that it is the employer carrier's burden to prove, or I'm sorry, to show that notice is given to the claimant. If notice is not given of the job search requirements, then the claimant is excused from performing a job search. Now, Mrs. Saeed, on behalf of the employer carrier, has...
I'm sorry,
Yes,
would
sir.
you at some point look to page 151 of the record, and I'm going to read it out to you, and this was argument of counsel for the employer carrier. Further, as far as supplements are concerned, he's been receiving IB impairment benefits based on the impairment rating. So that letter he's referring to will be out when he's actually due. Supplementals aren't even due until the end of the last impairment payments have been made. So in essence, he's not even sure that the claim is ripe as we sit here today. So that seems to indicate to me, it's on page 151 of the record.
May I get it, please?
Okay, go ahead. Because I'm trying to figure out how that works into the entire argument that we have here.
And that was counsel for the employer carrier.
Seeming to indicate that they're even admitting that no letter was sent out. So I'm wondering how that works with this whole argument about who has the burden of proof.
I'm not sure I understand what the lawyer is saying there.
As I read the lawyer, he's saying no letter was sent out. So it's almost an admission. I mean, I'm wondering if it was even an issue.
Well, he's saying no letter was sent out because none was required at that point.
Yeah.
And the other follow-up question, as you're cogitating about what the impact of that is did your trial counsel ever ask the claimant, did you receive the letter?
No.
So your claimant never established that he did receive the letter.
And that's why, Judge Thomas, I think it comes back. And this issue was not addressed in the original compensation order. My trial lawyer, my claimant's trial lawyer, brought it up during closing argument, and he is the one who said the employer carrier didn't present evidence. The JCC did not address it. The claimant's attorney moved for rehearing on several bases, but this was really the thrust of it, and it was in the amended compensation order that the judge addressed it. But Judge Webster and Judge Wolf, to go back to what you point out on 151, first of all, this was not argued in the employer carrier's response to the motion for rehearing. If the employer carrier's lawyer is saying we weren't 15 weeks before the end of the impairment.
Okay, well, what I'm pointing out here is this may work to your benefit. And I'm
I think it does.
I'm trying to figure out how that all plays out here.
Well, I think what plays out, it seems to me there are two things. First, you need to make a determination as to whether we had the burden of proof. But even if we don't have the burden of proof, there is a concession that there is no notice. If there is no notice of the requirement that the claimant make a job search, everything else that is emphasized by the employer carrier on appeal, and that is that the JCC did not believe the claimant's testimony about the job search, that he made an adequate job search. Well, his testimony is that he had just started like 2 to 3 months before the hearing. But if he does not know what kind of job search he has to make, the adequacy of that job search is not relevant. And in that regard, I do want to correct one thing in my brief. On page 12, I cited the Phillips case for the proposition that the job search is irrelevant. It should have been Alberta versus American Freight, which is discussed in the Phillips case.
Ms. Graham, under the tipsy coachman rule, it seems to me we have an obligation to affirm if the result is correct, even if the judge is wrong in his or her, in this case, her reasoning. If in fact the employer and carrier were not required yet to send out the notice, why would we not be obligated to affirm on that basis on the ground that it wasn't right?
Excuse me, that, whether they were required to send out the notice at that juncture or not, I believe, Judge Webster, would be an evidentiary issue as to whether they were within, I believe it's 15 weeks prior to the end of the payment of impairment benefits. And there's nothing in this record about that. Okay. So I don't think the tipsy coachman rule applies. What would happen, there are two ways you can go if you determine that the claimant's position is correct. First, you could simply reverse and send back with instructions to the JCC that where notice being given is not proven. And
I know you're in the middle of the answer, but I want to point out you have 5 minutes.
Okay, I'll use a minute. You would simply reverse and remand and say award supplemental benefits. Under your hypothetical, Judge Webster, assuming a tipsy coachman kind of rule where you don't have any evidence as to when the impairment benefits period ended and whether the letter was due at that point, you would have to reverse and remand to take evidence on that issue. If there are no other questions at this juncture.
Before you sit down, whose burden would it be to demonstrate present entitled to supplemental benefits? Present entitlement to supplemental benefits?
I think the claimants, and I see where we're going, but
no evidence on that either. You just said there was no evidence.
No,
on
there is no evidence on that. But that again ties into the notice requirement. If there are no other questions at this point, I will reserve the remaining time for rebuttal. Thank you.
Good afternoon. May it please the Court, Tara Saeed on behalf of City Furniture and Liberty Mutual.
Ms. Saeed, have you raised on appeal the argument that this claim for supplemental benefits isn't right?
No, Your Honor, and I can explain why I haven't. It's because when the attorney for the employer carrier made the statement that Judge Wolf just pointed out, I believe on page 151, that was in closing. The same argument that we're kind of here on today, where there is a kind of a new evidentiary argument brought out in closing. That's not the time to bring up evidence.
Okay. So as far as you're concerned, on behalf of the employer and carrier today, the only issue we need to worry about is who has the burden of proof to demonstrate either notice or lack of notice.
Correct, Your Honor.
Okay, thank
Correct. And I think as appropriately noted in the judge's order, where the judge stated that there was nothing in the record about this, opposing counsel started by saying that there was failure to give requisite notice about this requirement, about giving the claimant notice to do a job search. Well, the problem is there's not notice that the notice was given, and there's no evidence that the notice wasn't given. There's simply nothing. If you look at the focus that the judge did in this.
But where the record reflects, I understand your position that it comes up in closing, but where the record reflects, obviously, that there was not notice given. As a truth-seeking body, where does that put us? And I know we're not the truth-seeking body, but partially the JCC should be.
I'd have to say first that I don't agree that the record clearly reflects that no notice was given. I think it's silent as to that. I think the whole focus here was under the statutory three-prong definition under 440.15.3b about where it says that you have to prove an impairment benefit of 20% or over and the three different elements. And I think that is where the judge had concentrated whether or not the claimant was credible, looking at one portion on it, whether or not he was making at least 80% under that statutory definition. So I think that was the full analysis. And when you take the court's analysis with the evidence that was presented, the judge properly made a finding. Evidence is closed. End of the trial. Oh, by the way, in fact, it even stated in the motion for rehearing, that this really isn't a matter of law. They have to do this because they didn't do what they were supposed to do, them being the employer carrier.
And the claimant, I take it in the motion for rehearing, never took the position that the lawyer who tried the case for the employer and carrier had conceded that no notice had been sent.
He made the argument that there was a discussion about the claimant looking for work, what kind of work he had looked for, but I don't recall there being, that being conceded in there. I did want to point out to the court, though, the difference in some of the cases that were cited in support of the claimant's position, particularly the Alberto case. That it was cited for the purpose of saying that failure to perform a job search does not preclude or excuse the employer carrier's duty to advise the claimant of his entitlement. The difference there is on their record evidence, the claimant testified that the rehabilitation nurse nor anyone else said anything about needing to do a job search. That's the key, evidence, and at that point, the burden shifted. Now, as employer carrier, I would bring in a witness to say whether or not something had been sent, hadn't been sent, then the judge, as a finder of fact, would balance the evidence before him.
Do you think this is in the nature of failure to perform an adequate job search is in the nature of an affirmative defense? I mean, we talk about affirmative defenses, we're really talking about matters of confession and avoidance. And aren't you really saying when you raise that sort of issue for the employer, we concede that he would be entitled to the benefits, but he didn't perform the required job search? Isn't that what you're really saying?
Well, not really. What I'm saying is that...
And I don't mean you. I mean, isn't that what the nature of that argument is in that?
Yes, I would agree that that's the nature of that argument, but for the purposes of what was before this judge, and I don't believe that a judge can look outside of the four corners of what was presented and accepted into evidence as to how to make a decision. And as I stated earlier, the full analysis that was done here was whether or not the three requisites under 440.15.3b were met. It's an and, not an or. So to come at the end, it's kind of like, I was trying to draw an analysis to explain this and understand this. This would be like a claimant saying you have a whole trial over a back issue and this back injury this person has, and in closing, if the employer carrier to make a new argument that obviously this was a pre-existing problem and no evidence had been presented about that, well, Judge, can you reopen the evidence now so that we can go back and I can confirm that? Because, I believe he did.
What if the claimant's lawyer in your hypothetical said, Judge, we admit our client had a pre-existing problem, but we'd still like to obtain relief. Should we ignore that as well?
If he admitted it, he would.
Yeah, your hypothetical is flawed.
Yeah, but using his hypothetical, I think the claimant attorney would argue they knew about this all along. Why didn't they bring this up? It's too late now. You can't come back. He had to prove major contributing cause, and he didn't. All you have is what's before you, Judge, and what's before you is what was presented. So to apply that to this situation is what is before you is a petition properly filed asking for the supplemental benefits, an analysis done under the statute, no evidence raised as to the notice issue on this, and every single one of these cases that were cited where they talked about the burden shifting to the employer carrier, it was always where there was record evidence. In particular, in the Marbury case versus Holiday Inn, in that particular case, there was actual notice to the claimant was an issue. There was evidence as to it. Claimant said, I never got anything. And the employer goes, well, we sent something. You've got something for the court to consider. And then at that point, you look at it whether or not there was competent substantial evidence, which is why I felt that was the argument here, not a de novo interpretation of the statute, but competent substantial evidence to support the judge's finding. And here you can't apply evidence that wasn't there. If any other questions from the court, I have nothing further. Thank you.
regard to the comments made by the employer carrier's attorney on page 151, which was at the end of the merits hearing, I think counsel was getting confused there, because what she says, and looking at it and comparing it with the requirements of the administrative code, she says that as far as supplementals are concerned, he's been receiving IB based on the impairment rating. So the letter that he's referring to will be out when he's actually due. Supplementals aren't even due until the end of the last impairment payment's been made. That is not a correct statement of what the administrative code requires. The administrative code, which is set forth on page 6 of our brief, specifies that no later than 15 weeks before expiration of the impairment income benefit period, the carrier shall send by certified mail to each employee eligible for supplemental income benefits an information letter that complies with subsection 7, which puts the things that it sets forth the things you have to put in the letter. So respectfully, counsel, when she made this statement to the JCC, was wrong.
But your opposing counsel's conceded she's not making that argument.
She isn't making that argument, but I bring this up, Judge Thomas,
Okay,
so that I
She was
can...
wrong about, your argument is she was wrong about when
The
the
notice
letter
had to be given.
sent. But is there any way that we can utilize that language? Because it seems to indicate
That they
there was
didn't
no letter
send it.
sent. Is there any way that we can utilize that language in support of your argument? And I guess the question comes down to, it was done during closing argument. It was not part of the evidence.
It's not part of the evidence, but I believe it is a concession, and certainly you can use a concession. And I do want to retract what I said earlier about what the two ways you could go are, because now that I have looked at this more carefully and looked at it in view of what the administrative code requires has to be done under the statute.
Okay, we'll accept that you haven't conceded that
Okay.
your client wasn't, that the benefits weren't right. And I certainly understand your point and accept it.
Okay.
You know, that the issue's joined in the sense of, because your opposing counsel said, I'm not arguing that they failed to establish benefits might be right. I'm arguing that there was no evidence regarding the letter at all. So I think the issue's pretty well joined.
And that comes back again, Judge Thomas, to what I said at the beginning. That is, who bears the burden of proof? And I think under the statute and under the administrative code, the burden is on the employer carrier, and all the stuff about sufficiency of the job search is irrelevant because you don't have to do it. With no other questions, I see I'm on a red light, and we'd ask you to reverse.
Before you sit down, I have a question. The argument that you don't have to make a job search unless you get the notice is premised exclusively on the rule, isn't it? There's nothing in the statute that says that.
Well, it's really premised on, I think it's premised on the numerous cases that say
Those all deal with wage loss benefits.
they do, and I think
Because the statute is silent. I'm sorry for interrupting in your exchange, but the statute says what you have to do.
correct.
What the claimant has to do. It's only the rule
I think
that implies the burden might be the carrier's.
I believe subsection 18, 440-18, sets forth who, it doesn't deal with supplemental benefits, but it does, as I recall, and it's been a while since I've looked at it, says what the burdens are, or I'm sorry, what the responsibilities are of the employer carrier and the claimant.
Where do we end up if it turns out we conclude the rule is inconsistent with the statute? Is the rule still valid?
The administrative code. I have not researched that issue. If you want a supplemental brief, I'll be happy to do it.
No, but I mean,
However,
it seems to me it's fairly clear when I read the statute in the rule that there's nothing in the statute that expressly justifies the burden put on the employer and carrier by the rule.
Yes, but why can't you use the impairment benefit cases? There is, I think, one supplemental benefits case that I cite, but I don't believe it addressed this specific issue. But if you want a gut reaction, Judge Webster, where the administrative code implements the statute, but the statute, I think, would have to control over the administrative code. But if you look at the entirety of the case law dealing with workers' compensation benefits and the burdens that are put both on the claimant and the employer carrier, and the employer carrier, at least under the impairment cases, always has the burden to tell the claimant what his rights and responsibilities are. And this is a non-English speaking manual worker.
Thank you.
Thank you.
Thank you. What we're going to do, I invite counsel to stay up there. I'd like to